So let me set the context a little bit. This particular opinion is exactly that. It's an opinion. It's distinct and different to the judgments that were given earlier in the year with regards to the case that South Africa brought against Israel at the International Court of Justice pertaining to the war that's currently raging between Gaza and Israel. This is very different. This is as a result of a resolution that the General Assembly of the United Nations passed in December of 2022 saying, please give us an opinion, International Court of Justice, as to the impact of Israel's continued occupation of the occupied territories, namely in Judea and Samaria, another word being Gaza, as well as with the West Bank. Number one, this is not a binding judgment in any regard. People are now going, oh, this is international law. Israel better listen. She's now found guilty of committing war crimes. Absolute garbage nonsense. This literally was the General Assembly saying, hey, tell us what your thoughts are. All right. And that's exactly what happened. We then have the court, which comprises 15 judges, who 14 of them then assent to the majority ruling. And then there's one dissenting opinion that is given by a judge who we need to thank God for, who I, as an African, particularly an African woman, want to say, thank you, Lord, for this example. And that is Judge Julia Sebutili. She comes from Uganda. She was born in Uganda in the 1950s. She was first appointed to the court in 2012 and then again in 2021, and she was appointed to the position of vice president in February of this year. She has consistently applied principle as it pertains to the application of not only international law, but also the function of the court. Because the very same way that we in many other examples say that Israel is a canary in a coal mine, that how Israel is treated, how the Jews are treated is an example of exactly how society is going to be treated. The exact same thing here. If the International Court of Justice is allowed, if organizations, if world bodies, if governments continue to allow and use the International Court of Justice as a means of political warfare against Israel, then the mechanics that uphold the International Court of Justice are going to fall apart. And then when people really do need some sort of assistance, when there are real genocides that are happening, when there are real issues facing particular people that need to be addressed, where's the principle going to be in order for those people's plights to be addressed? Like it's going to be gone. And this is unfortunately what we're starting to see at the International Court of Justice. For those that have not really been paying attention, I encourage you to go and research the dissenting opinion that Judge Julia gave in January 2024, where the court was looking at, as a result of the case brought against Israel by South Africa, that is there genocide that's happening, right? And one of the statements that she said in her opening, if I may read, is that she said, in my respectful dissenting opinion, the dispute between the State of Israel and the people of Palestine is essentially and historically a political one, calling for diplomatic and negotiated settlement, blah, 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 blah. And she basically says that it is not a legal dispute susceptible by judicial settlement by the court. So she's saying, don't come here and use the court as a means of settling something that should be done in politics. Again, she shows a similar vein in her arguing against the majority opinion in the decision that was given by her in May. And so there's just this consistency. In this particular opinion, she highlights, and we're not going to go into it now, but there is a rule of law that is important for us to note, and she highlights the uti possidetis juris principle. What does that mean? It means that when there were countries that were coming out of colonialization, as they were in the early 1900s and even late 1800s, it was generally accepted at the time, and it became then international customary law, that the borders that those countries had, those emerging states, those emerging countries had in their colonial state, those were going to be the borders then that were going to be kept unless otherwise agreed as those states emerged as independent entities. So this particular rule also was applied in 1948 when Israel declared independence after the Independence War or during the Independence War. And so now what we're seeing is that this court is challenging this principle and pretty much saying that this principle doesn't apply, because they're now saying, oh, Gaza and Judea and Samaria are occupied by Israel. Couple of issues there immediately that are wrong. First of all, there's no occupation in Gaza. For those of us that know our history, in 2005, Israel withdrew everything, even its graves, even its dead people, the bodies, right? The bones, it withdrew in totality. And so even this de facto control that people are now trying to argue about because of the restrictions of movements in and out, which is purely because of this genocidal intent that Hamas has in relation to Israel, There is no control there. And then when you look at Judea and Samaria, they're saying, oh, no, no, no. As a result of the 1967 war, when Israel recaptured this land, and then we had the Oslo Accords, and I'm skipping through various parts of history, there is now occupation. First of all, that land that was there was taken back by a sovereign entity because it was previously theirs. And it was as a result of a defensive war. And so even if you look at the laws of international wars, it legally obtained that land back. Why is there only this outcry with regards to the 1967 borders? Before 1967, who occupied Judea and Samaria? Who occupied the West Bank?
It was Jordan.
It was Jordan. Oh, but we don't need to talk about Jordan.
Yep.
There was never an issue there. Who occupied the area of Gaza? It was Egypt. But only when Israel then gets back its land, which it has had, not only in terms of UN resolutions from 1948 and after, but let's go back thousands of years where in terms of sovereignty, that land belongs to Israel. So there is a legal claim that Israel has in addition to a moral claim and all of these other things. But then there's also a couple of other issues, because this particular opinion not only misstates the law, not only misstates the facts. One of the things that the main opinion says is that there was no facts that were brought to it, pretty much, and again, I'm paraphrasing because it's so detailed, that there were no facts that were brought to it to showcase Israel's stance and position on the matter. But then in Julia's opinion, she's like, oh, no, we did receive facts. So it's like, okay, but now you're also blatantly lying. It's problematic on many, many, many levels, this opinion that was issued. But thank God, really, in the most strongest terms, that we have Julia from Uganda, an African who pretty much is standing in the gap. It also negates the fact that in various reiterations of peace agreements and other resolutions, including the Jordan Peace Agreement, including the Oslo Accords, that reference the fact that this particular area belonged to Israel as a result of this uti possederis principle, like it just negates that. So it's like disappearing act, like, like a musician with a wand. Oh, we don't care about history. We don't care about facts. We don't care about all these agreements that are real and that are alive as a result of this, because we need to find Israel guilty. It's bizarre and it's wrong and it's very problematic.